Hello, I'm Wilberforce Agyekum, an attorney at Ivy Law Office. I practice immigration law. Today I'm going to talk to you briefly about one of my favorite areas of immigration law. I have had an experience working with musicians and artists in the past, and so I really appreciate the opportunity to work with some artists from outside the U.S. who are interested in coming to the U.S. To perform and work. So, briefly, we're going to talk about the P-3 Artist or Entertainer Visa. So, the P-3 Artist or Entertainer Visa is for those coming to be part of a culturally unique program. The P-3 classification applies to you if you want to come to the U.S. to temporarily perform, teach, or coach as an artist or entertainers, individually or as part of a group, under a program that is culturally unique. So remember that part. The program must be culturally unique. And if you typically be coming from another country, um, you can make a case that your program will be culturally unique. The eligibility criteria for the P3. For a P3 visa, you must be coming to the United States either individually or as part of a group for the purpose of developing or interpreting, representing, coaching, or teaching a unique or traditional ethnic, folk, cultural, musical, theatrical, or artistic performance or presentation. In addition, you must be coming to the United States to participate in a cultural event or events which will further the understanding or development of your art form. The program may be of a commercial or non-commercial nature. Now, the application process. The U.S. employer or the agent or sponsoring organization must submit Form I-129 petition for non-immigrant worker. This is a non-immigrant visa, meaning you are coming here temporarily with plans to return. Now, supporting documents. The I-129 form must include the following documents: a written consultation from an appropriate labor organization, a copy of the contract between the petitioner and the beneficiary, or the summary of terms of an oral agreement between the petitioner and the beneficiary, an explanation of the event and itinerary, affidavits, testimonials, or letters from recognized experts attesting to the authenticity of your or your group's skills in performing, presenting, coaching, or teaching the unique and traditional art forms, and giving the credentials of the expert, including the basis of his or her knowledge of your group's skills, or documentation that your or your group's performance is culturally unique as evidenced by reviews in newspapers, journals, or other published materials. Documentation that all the performances or presentations will be culturally unique events. Now, note this: if the events or performances will take place in multiple areas, an itinerary must be submitted as well. The itinerary must list the dates and locations of the events. Now, the period of stay. The initial period of stay for the P3 visa is not to exceed 1 year. You may, however, be able to extend your stay if you need to in order to continue your performances. Those can be extended for periods of 1 year increments. Okay? Form I-129 is used to apply for change of status, extension of stay, or change of employment. Change of employer. You may change employers, but only after your new employer has filed a new Form I-129 with the USCIS requesting permission to employ you and extend your stay. You may not commence employment with the new employer until the Form I-129 with that new employer has been approved by the USCIS. Now, your family of P-3 visa holders, your spouse and unmarried children under the age of 21 may obtain a P-4 status. Your dependents may not engage in employment, but they may attend school or college. Now, also, your essential support personnel. Essential support personnel who are an integral part of the performance of a P-3 artist or entertainer and who perform support services that cannot be readily performed by a U.S. worker are eligible for P-3 classification. Support personnel may include coaches, scouts, trainers, and other team officials and referees. The U.S. employer must file a separate Form I-129 for support personnel. The petition must include the following documents: a consultation from an appropriate labor organization, a statement describing the support person's prior and current essentially critical skills and experience with the P-3 artist or entertainer, a copy of a written contract between the employer and the support person, or a summary of the terms of the oral agreement under which support persons will be employed. That's all it takes. So, first, obviously, you need an invitation from an employer, an agent, or someone who will be responsible for you being in the United States to engage in those activities. So, that's the first step. And typically, that's the process. So, you can either search or apply or look for someone who may be interested in your talents and your skills. And remember, must be culturally unique, and you'll be able to at least have that employer or agent or the sponsoring organization petition via that Form I-129 on your behalf. Okay, so that's briefly it for the P-3 visa. If you have any questions or if you need assistance, please give me a call, Wilberforce Agyekum. You can reach me by phone at 301-276-0887, 301-276-0887, or you may reach me through the website, ivylawoffice.com, ivylawoffice.com. Okay? All right. So that's it for now. And if you are coming to the U.S. to perform, let me know. I'd love to check you